Good afternoon. We are here on the record in the matter of D-101 CV 2020-00328, Thomas McGill et al. Versus John Bassett et al. Will parties on the line please state your entry appearance?
This is Adrian Terry. I am the attorney for the plaintiffs in this action.
Okay.
Good afternoon, Your Honor. Marcus Rael, Robus Rael, and Anaya on behalf of the town of Edgewood.
This is Audrey Jaramillo, appearing pro se, governing body member of the town of Edgewood, Your Honor.
All right. Parties, while one is speaking, please mute your line. There's a lot of feedback that we're hearing, so if you are on this line, please, while another party is speaking, mute your line. Thank you. We're here today. There is a defendant's governing body for the town of Edgewood's amended motion to set aside default judgment and summary judgment and motion for expedited decision and expedited hearing. Are we ready to proceed on behalf of the defendants, Mr. Rael?
Yes, Your Honor.
Your Honor, we do have a preliminary matter.
Okay, please mute your lines. I'm sorry, I can't hear you, Ms. Jaramillo. Persons that are on the line, please mute your phones. We're getting a lot of feedback. We cannot hear the person speaking. Okay, go ahead, Ms. Jaramillo.
I just wanted to ask, since we do have a preliminary matter, governing body member Sherry Abraham and I are here as well, and we filed a motion to intervene and strike, and would like to address this first, if we may.
All right. From the other parties, Mr. Terry?
No objection, Your Honor. I do believe that the motion to intervene, a copy of which I received yesterday, does raise a preliminary matter that the court needs to address to determine whether or not Mr. Rael can in fact represent the town in this proceeding.
Mr. Rael?
Your Honor, I received a copy of the motion yesterday as well. I'm prepared to address it if you're prepared to do it, Your Honor, although I'm afraid we may run out of time on the other issues since you've only set aside a half an hour for today's hearing. You're muted, Your Honor.
My mouth is moving, but you can't hear me. Excuse me. Yes, we'll go ahead and proceed to hear the preliminary matter. Since all parties agreed, but we'll ask that Ms. Jaramillo that you make it brief since we are limited on time here this afternoon.
Yes, Your Honor. At this time, we just have two main concerns, governing body member Abraham and I. First, that there has been no authorizing vote by the governing body for these actions and these positions by Mr. Rael. We've been requesting closed sessions on this matter, but that's been refused by the mayor. And then secondly, that spending town money for Mr. Bassett violates the anti-donation clause in the Governmental Conduct Act, yet he continues to direct the attorneys in matters not only for the town's interest, but for himself as well. And really, he wants us to fight. It appears to me that he wants to fight the writ of mandamus, which really, Your Honor, is to fight enforcing our own ordinance, of which he is the subject in this action. So Abraham and I, Sherry Abraham and I, feel this is very improper, and just another example of John Bassett wanting to benefit himself by directing the town attorney to strike all these judgments. The town attorney, without the specific authorizing vote, is asking the court to set aside these judgments in total, which pertain to John Bassett personally using taxpayer funds to do so. And really, this is, Your Honor, you're going to see the very essence of this lawsuit, where he's, abusing his power and sidestepping counsel. We did have one meeting that was solely to determine that we didn't want to take over the Keytown suit as lead plaintiffs, but the body has not discussed this matter before us today.
So at this time, Ms. Jaramillo, what are you requesting from the court?
Requesting, Your Honor, that we be given the opportunity to go back and have a closed session meeting with our legal counsel, Mr. Rael, if he's going to choose to continue to represent the town and not Mr. Bassett. Those are two totally different things, as you know, and so that we can take a look at this order and this writ of mandamus and determine what position the governing body would like to take. I can tell you for Counselor Abraham and I, we simply want to comply with your order and we want to follow the laws. You simply asked us to enforce our ordinances, and Member Abraham and I want to do that.
Okay. All right. Thank you, Ms. Jaramillo. In response, Mr. Terry?
Yes, Your Honor, although I'm not a party to the conversations between Mr. Rael and the governing body members for the town of Edgewood, I do believe that the issues raised by Ms. Jaramillo today raise an issue as to whether or not Mr. Rael is properly authorized by a political subdivision of the state of New Mexico to represent the town in this matter and take any position that has not been duly authorized by the governing body. Given the fact that I think that there is some question about whether or not Mr. Rael is in fact authorized, I don't think it's appropriate for the court to hear argument from him today on the town's behalf where that issue seems to be in dispute. Clearly, I think this is a legislative matter that's going to have to go back to the governing body for the town of Edgewood to consider in a public meeting and to take some sort of action on how they would like to proceed in this matter. I would say that the plaintiffs have diligently monitored the town of Edgewood, its agendas and its meetings over the past couple of years, but we are certainly aware that within this calendar year and since the time that the lawsuit was filed, despite repeated requests by Councilor Jaramillo and Councilor Sherry Abraham for an update on the litigation specifically in this matter, the town refused to take any action on it and bring it before them. So I think that the meeting minutes for September 3rd, wherein the town considered whether to intervene in this action as the plaintiff in its own name as opposed to through the Ketam plaintiffs, the only issue discussed was the Ketam issue. There was no vote or official action of any form whatsoever with respect to how the town was going to respond to the count for the writ of mandamus, which was in the initial complaint and carried over into the amended complaint.
Thank you, Mr. Terry. Mr. Rael, your response?
Thank you, Your Honor. May it please the court. What we have here, Your Honor, is two disaffected members of the city council, Councilor Jaramillo and Councilor Abraham, are in the minority in the town of Edgewood at the current point in time and have been for the entirety of Mr. Bassett's term as mayor. Your Honor, I've been the town attorney for the town of Edgewood for about 15 years, maybe a little less, a little more. In that time, I've worked with most of these councilors and have enjoyed doing so. However, I've never seen the town more divided than it is at this point in time. But I'd like to point out, Your Honor, that as town attorney, under the scope of my duties in my contract, which I've attached to, so Your Honor, I apologize for how late everything was, but getting this yesterday, I filed a response to their motion to intervene and strike pleadings just about half an hour ago. And attached to that, I attached as one of the exhibits my town attorney contract. And in the contract, one of my duties is legal representation of the town, its political subdivisions, as well as individual councilors and other town employees who may be named as parties in their official capacities in any and all legal actions. Your Honor, shortly after the March 2nd, 2020 initial filing of the amended complaint, the governing body for the town of Edgewood convened a meeting at which Robles Brown and I my law firm was present along with the governing body. During the meeting, there was a discussion about the amended complaint and the allegations contained therein. And during that meeting, the governing body gave direction and input to me regarding representation of the governing body in the suit. It was clearly understood that the law firm was to zealously represent the governing body in this pending matter. However, Your Honor, as you know, and I'll get into this shortly, Mr. Terry amended his complaint and filed it as a QTAM, which is under an entirely different statute and which added significant delay and significant questions of law to the complaint. Your Honor, attached to my motion as well are exhibits A through C, which are affidavits of Mayor John Bassett, City Councilor Hawley, and City Councilor Abrams, who's different from City Councilor Abraham, all of whom in their affidavits state that they fully understood the law firm would provide vigorous and competent representation in litigation proceedings stemming from this lawsuit, as well as stating that at the September 3rd, 2020 meeting, they gave during the executive session, which is, as you know, Your Honor, under the Open Meetings Act in the state of New Mexico, during the executive session, they gave their approval and direction to the law firm to represent and defend the governing body in the present lawsuit. Your Honor, I'd like to move on real quickly to a legal argument, and that is that I do not believe that Councilors Jaramillo and Abraham have standing to be in this lawsuit. The Rule 24 of New Mexico Rules of Civil Procedure state that upon timely application, one shall be permitted to intervene in an action unless the applicant's interest is adequately represented by existing parties. In this case, Your Honor, the majority of the governing body is the party. The governing body is the party. The majority of the governing body has requested that the law firm defend the action in a certain way. And what you have here is the minority members of the governing body attempting to intervene in this action, which is not allowed under Rule 24. Rule 24, subsection A, subsection 2 requires a person claiming a right of intervention to demonstrate an interest in the action that is significant, direct, and based on a right belonging to the proposed intervener rather than to an existing party in the suit. And in this case, Your Honor, the governing body of the town of Edgewood is an existing party to the suit, and the majority of that governing body has instructed me to defend the town of Edgewood in this lawsuit. Therefore, Your Honor, I'd also like to state that that slide I just read was under New Mexico Right to Choose v. Johnson, which is 1999 New Mexico Supreme Court 005 at paragraph 17. Your Honor, in addition, the town of Edgewood has passed, approved, and adopted an operating resolution number 2020-02, which specifies that the governing body includes the council members and the mayor, and I've attached that resolution to my response, Your Honor, as Exhibit D. As such, Your Honor, when the majority of the governing body votes or makes a determination, that decision stands and binds the entire governing body to that decision, and that's the way that that our legislative process works in this country. As stated before, Your Honor, at the September 3rd council meeting, it was unequivocally understood that the law firm was to represent the governing body in this matter, and you'll see that again, Your Honor, in the attached affidavits of Mayor Bassett, Councilor Hawley, and Councilor Abrams. And so as evidenced by those affidavits, Your Honor, I've been ordered and instructed by the governing body, by the majority of the governing body of the town of Edgewood, to provide vigorous, competent representation in litigation stemming from this lawsuit. The movements in the minority movements in this case, Your Honor, are attempting to subvert the majority decision of the governing body by filing their motion to intervene. In their motion to intervene, the movements failed to demonstrate, quote, an interest in the action that is significant, direct, rather than contingent, and based on a right belonging to the proposed intervener rather than to an existing party in the suit. And again, Your Honor, that's 1999 New Mexico Supreme Court 005, which is the seminal case regarding intervention in the state of New Mexico. This failure is also contrary to the requirements of Rule 24, that disposition of the action may, as a practical matter, impair or impede the applicant's ability to protect that interest. So, Your Honor, in the light of the fact the majority of the governing body provided direction to the law firm to represent them in this matter, we would ask that you do not allow them to intervene at this point in time. Your Honor, I also have another section in my brief, which I don't know if it's necessary to get into, regarding the fact that it's the opinion of both myself and the town of Edgewood governing body, the majority of the town of Edgewood governing body, that the brief that was written by Councilors Jaramillo and Abraham was ghostwritten by someone. I lay out several examples. I lay out the case law prohibiting that. Your Honor, I don't know if you need to get into that in order to make your decision. If you'd like me to, I can do that. In the alternative, Your Honor, I would simply ask that you deny the movement's expedited motion to intervene and to strike the pleadings, and that you allow me to continue in my representation of the town of Edgewood governing body. I stand for any questions, Your Honor.
Thank you, Mr. L. I'm going to allow Ms. Jaramillo for a brief reply.
Thank you, Your Honor. I did want to point out that there hasn't really been a question of Mr. Royale representing the governing body. In the lawsuit in general, I would say, however, when it comes to specific decisions and specifically this writ of mandamus, we have not had the chance to discuss this as a governing body together. He's been instructed separately by Mr. Bassett. And so it's one thing to be the town attorney. It's another thing to, receive direction from someone who these actions are against. The governing body, as I see it right now, is the 4 council members. This mayor is no longer legally the mayor at this point in time. As far as Councilor Abraham and I being in the minority, that may be the case as far as votes go. But I did want to make you aware that recently the community is very, very upset about these corrupt actions of the mayor. And we recently had a special election of which 7 out of 10 people disagreed with the mayor's position. And they have determined that this is no longer a mayor council form of government. So there really is no mayor position, but a commission manager form of government. So really, as you can tell, there's a lot going on in the community. I would say we are definitely not in the minority in this, and the governing body absolutely needs to be given the respect to have a meeting with their legal counsel. Now, with that being said, Mr. Ryle needs to choose. Is he representing the governing body or is he representing Mr. Bassett? And if he's representing the governing body, then we need to have a meeting together in this matter to determine how to move forward. And also with that being said, like I said, my second concern, or our second concern, is that town money is being spent where it shouldn't be, because really the town's part of this is only the writ of mandamus, of which you ordered us to follow our own ordinances. So I think he's just kind of pointing to all these other issues that are not really the problem here. And I would like the governing body to have the chance to meet on this and instruct him. But it needs to be whoever's going to actually represent us without a conflict of interest. Thank you.
Thank you, Ms. Hodge. Mr. Terry, it is the complaint and as pled, is this against the governing body or Mr. Bassett individually? Is this, can you clarify for the court?
Yes, absolutely. Thank you, Your Honor. The complaint alleges, and I'll take it in sequence. There was an initial complaint, and then there was the amended complaint. But with respect to the initial complaint, there were allegations pled against the mayor, and there was a single count pled against the town, which was for a writ of mandamus to require the town to initiate a complaint against the mayor for malfeasance in office, which plaintiffs contend was a violation of the town's nepotism ordinance. So that was the allegation against the town. The allegations against the mayor were multiple, but ultimately to have him removed under the Quo Warranto statute for misuse of public funds, under a cause for declaratory judgment, aka the violation of the nepotism ordinance, and for fraud. When the plaintiffs amended their complaint, they added a qui tam action under the Fraud Against Taxpayers Act. This action is now brought in the name of the town of Edgewood by the plaintiffs as the relator parties, the qui tam plaintiffs, and it's against John Bassett, the mayor. So the parties are directly adverse in the action. And I do believe that there's a conflict between them, and their representation can't be by the same attorney. At the time of the amendment, we also added a count for unjust enrichment, which was to say that the mayor's improper actions benefited someone, and we named the beneficiaries. But that's the nature of the complaint. The only count against the town is on the writ of mandamus. That was count 3 in the initial complaint. It was carried over as count 3 in the amended complaint. It's identical. The language is verbatim. There was no change to that count. So I believe, based on the information that I've heard, and again, I'm not party to this motion, but there seem to be disputed issues of fact. There's obviously been some legal arguments raised. The motion to intervene was filed yesterday. I received Mr. Ryal's brief about 18 minutes before this hearing started. And it looks like exemplary work. I'm impressed you could crank the paper that fast. But nevertheless, I have not had an opportunity to review it in any detail, and I think it's an issue that should be briefed before the court.
May I respond?
You may, Mr. Rao, go ahead.
Your Honor, the complaint is alleged against Mayor Bassett individually and in his capacity as mayor for the town of Edgewood, number one. Number two, I'm not asserting, nor am I trying to represent Mayor Bassett in either his individual or official capacities. I've had several discussions with Mr. Terry about the fact that there is a conflict and that Mayor Bassett, that I need to find counsel for Mayor Bassett. However, Your Honor, as you know, it's, with procurement policies, with the state procurement code, it takes time to do this. I've had these discussions with Mr. Terry, and we are in the process of trying to get a contract signed for someone to represent Mayor Bassett in his official capacity as mayor of the town of Edgewood. Another point, Your Honor, that I'd like to make, that it was brought as a qui tam action. It was brought originally as state of New Mexico, ex rel. Thomas McGill, Jerry Powers, and Howard Calkins versus John Bassett in his individual and official capacities and the governing body of the town of Edgewood. The state attorney general's office refused to take over as the qui tam plaintiff. Therefore, it's no longer state of New Mexico, ex rel. And the caption hasn't been fixed. Then it fell, and after that, it fell to the governing body of the town of Edgewood to decide whether or not they wanted to take over as the qui tam plaintiff against Mayor Bassett in his individual and official capacities, as well as the other members of the suit. The governing body declined to become the qui tam plaintiff in that action as well. So it's no longer town of Edgewood, ex rel. These individuals. It's simply these individuals versus the governing body and the mayor and the other two defendants in the case. Secondly, Your Honor, in order for the writ of mandamus to be valid, this all, Your Honor, and I'll get into this in a minute when we get to my actual motion, but in order for the writ of mandamus to be valid, the mayor would have to be found guilty of the other counts in the amended complaint in order for the town to have a valid writ against it to remove its own mayor. The mayor would have had to have been found guilty. Therefore, these claims are inextricably intertwined, Your Honor, and can't be separated from one another, and it needs to be adjudicated as a whole in order for Your Honor to decide whether or not there really is a writ of mandamus to be against the town of Edgewood. I have not, I think I've made it very clear, and I would ask for some candor from Councilors Jaramillo and Abraham and Mr. Terry to the court, Your Honor, that I have made it clear to them that I do not represent Mayor Bassett and will not be representing Mayor Bassett. I'm simply representing the governing body of the town of Edgewood. Your Honor, this all started because Mr. Terry failed to follow the rules correctly, presented an order to Your Honor, which presented a motion which was not a motion for summary judgment and a motion for default judgment, which, despite the fact that he knew I represented the town of Edgewood, was not served on myself, nor, even if you want to be out of Your Honor, wasn't served on any of the defendants.
Mr. Ryle, before we get into the substance of the motion to set aside the default judgment, explain for this court how you reconcile the conflict that exists between representing the mayor and the town. You filed a motion to set aside the default judgment, and how you reconcile that. Are you filing that on behalf of the town, or are you filing on behalf of the mayor? Please explain for the court how you are reconciling the existing conflict between the mayor and the town of Edgewood.
So, Your Honor, there is a conflict once we start representing, once the lawsuit is to move forward. The motion that I filed, as you'll see, Your Honor, I entered my appearance solely on behalf of the town of Edgewood. However, because the writ of mandamus requires that the mayor would be found guilty on the other claims against him, the argument is the same. The motions were not served on the mayor in his official capacity or in his individual capacity or on the town of Edgewood, Your Honor, and therefore they need to be set aside and the case needs to be allowed to move forward. I would also ask Your Honor to take notice of the fact that Mr. Terry and I had numerous conversations and he had granted me time to find counsel for Mayor Bassett in his official capacity. And we were going to, I was explaining to him the long drawn out process about hiring somebody to work for a governmental entity. He had granted me an extension of time. I foolishly, Your Honor, did not do that in writing, although I doubt Mr. Terry, although he had.
I'm sorry, please mute your lines. Mr. Al, before we're getting into the motion again. Hold on. Okay, I'm sorry for interrupting you, Mr. Al, but it is important this court to determine before we move into the merits of your motion to set aside the default judgment, what is the existing conflict, and then whether we should move forward on that particular motion, because it appears by what you've stated to the court, you are representing Mr. Terry in his personal capacity as well as the town of Edgewood in this motion for default judgment. Is that correct?
Your Honor, I'm running the town of Edgewood governing body, a member of whom is the mayor of the governing body, pursuant to state law as well as to its governing procedure. I will not be representing the mayor moving forward in the lawsuit. However, in order for the lawsuit to move forward, these judgments need to be set aside. And so I'm representing the governing body, which for purposes of this motion only, my motion only, does include the mayor.
Response, Mr. Terry? Then I'd like for Ms. Jaramillo final.
Yes, I would say as to this issue on the preliminary matter, I believe that what has been presented to the court today is a direct conflict of interest between two parties, Mayor John Bassett and the governing body for the town of Edgewood. And I believe what we have is a representation by Mr. Rial that for purposes of this motion, that he has filed it on behalf of both parties because he sees that they are joined or unified in some way. I'm not sure if that's proper. I leave that to the court.
All right, Ms. Jaramillo, yes, go ahead.
What I see here is that even if they had the authority to do this, he's trying to get the total judgment set aside, most of which is not the town's to defend. It would be limited to the writ of mandamus judgment only. And so here we are without even an opportunity to discuss where the governing body itself wants to stand on enforcing our own ordinance. So Mr. Ryle has taken a position to you, the court, that he wants the town to fight this and set all of this aside. However, there's been no vote, and there's not even been any discussion with the governing body. And like I said earlier, Councilor or governing body member Abraham and I want to follow our ordinances. We want to follow the law. So why is our own attorney telling us and fighting the court on just simply following the law? That doesn't make any sense to us at all. It just doesn't make sense. He's filing something to say that we are fighting back on your order to follow our law. And that just doesn't make sense. Plus, now I hear he's going out to procurement. Again, my second concern, town money is being spent to defend John Bassett in all of these individual capacities. Thank you.
Your Honor,
Yes.
there's several types of procurement, some of which require it to go through the governing body, some of which don't. But Your Honor, maybe the simple solution is for you to allow, as I requested in my motion, is for you to allow Mr. Bassett to get counsel on board. And at that time, you can hear the motion to set aside the default judgment, which is against Mayor Bassett. And then, the summary judgment, which is against Mayor Bassett. And only hear today the motion to set aside the default judgment against the town of Edgewood, if you'd like.
And the only count that's related to the town of Edgewood is the count 3 related to the writ. Is that correct, Mr. Terry?
That is correct, Your Honor.
Okay.
Your Honor, they are inextricably intertwined, and by Mr. Terry failing to follow the rules, you have an order that you entered mistakenly, in my opinion, which has effectively removed a mayor from office, which, as you know, Your Honor, is going to cause a lot of problems, and it should be heard on its merits. It should not have been entered into mistakenly because Mr. Terry failed to follow the rules of civil procedure.
Okay. And I'm hearing you, Mr. Allen. What's concerning is that on one hand you're representing the town of Edgewood, but on the other hand you're defending Mr. Terry on what his rights are, and you've also stated that Mr. Terry does need his own representation. If you are representing the town of Edgewood, then you are limited to the writ, which is the count 3 of the complaint as alleged, and they are inextricably intertwined, which makes this even a larger conflict. And I do think this is something that the City Council should address in moving forward. The court is not going to hear the motion for default judgment today based on that your representation is a conflict of interest to the City of Edgewood as well as to Mr. Bassett, and that if this is to go forward, you may proceed only on the count of the writ of mandamus affecting the town of Edgewood. However, if this motion is to be entertained, it should be filed by an attorney who is representing Mr. Bassett at that time. So I'm going to grant the City Councilor, Ms. Jaramillo and Ms. Abrams' motion to intervene and to strike the pleadings at this time. And I will ask you to draft that order, present it to council, get that to the parties and to the court. So at this time, the court is not going to entertain a motion for default judgment until filed by the appropriate party for each entity alleging their claim. Anything else? Yes. I can't hear you, sir. Are you muted, Mr. Ryle?
I apologize, Your Honor. I was muted. just to be clear, Your Honor, you're granting the town of Edgewood time to make a decision. You're saying I'm going to have a vote by the governing body to determine whether or not they want me to represent it in this lawsuit going forward. And then number two, are you granting Mayor Bassett the opportunity to get counsel? And if so, will you stay your orders until such time as Mayor Bassett has counsel and that decision has been made, and it can all be done quickly? And then we'll have another hearing. But right now you have this group trumpeting out there that the mayor has been removed from office, which was done in a manner which was done, in my opinion, Your Honor, as a mistake and was not done properly following the statute. So will you please consider staying your orders until such time as these motions are heard by Your Honor, and we can do it quickly as Your Honor, as soon as Your Honor wants to set it.
Response, Mr. Terry?
Yes, Your Honor, I would wholly object to that. I think as an initial matter, Mr. Bassett, Mayor John Bassett, is a party to these proceedings. As reflected by the court record, he has been served with process in this action. He has failed to appear or file any responsive pleading contrary to the rules of civil procedure. Obviously, there are some procedural technicalities in this particular case, but nevertheless, he has received process. He has notice of the action. And you'll note that in my response to the town's brief that I included an exhibit, which is Mayor Bassett giving a rebuttal of the lawsuit in a local newspaper. So there's no issue as to notice. He's not a party before the court, and I don't believe the court can grant him relief through Mr. Rael or otherwise. The other thing that I would suggest is that the court does not stay these orders, does not grant the town any additional time. And I think that the record is clear based on Mr. Rael's own statements before the court that he had an obligation to zealously represent the town, that he had numerous meetings with the town, yet he failed to enter an appearance in this case until October 12th. That delay is inexcusable, and it shouldn't be something that works to his benefit before the court today. Thank you, Your Honor.
Your Honor, the key TAM statute requires Mr. Terry to properly serve the parties following the order to lift the seal, which was not done until September 16th, 2020, Your Honor. We're going to get to that.
No, Mr. Rael, the court has made its decision, and I will not stay. I'm going to deny your request to stay the proceedings. There has been ample opportunity for a response to have been filed in this matter. There hasn't been at this point, regardless of the excuses. Right now, what the court is not going to entertain is the decision of the default is in place and will remain in place. If there is a party on behalf of Mr. Terry or the town of Edgewood wants to file on town of Edgewood, which only relates to count 3, they may do so. And then Mr. Terry, if his counsel requests to do that, but right now the court finds that you do not have the standing, Mr. Rael, to proceed in making any motion to stay this proceeding. So therefore, the court will request that remain in place.
Well, Your Honor, will you please just hear the motion to set aside the default judgment, which is just on behalf of the town today? There's 2 different motions. One was a summary judgment motion. One was a motion to set aside a default judgment. I think it'll become clear if you allow me to present my argument, Your Honor, that's only on behalf of the town of Edgewood, but it'll show you why these are inextricably intertwined, and it'll also show you why Mr. Terry, because he chose to proceed under the key TAM statute, it's not the rules are different, and he did not follow the rules. So Mayor Bassett was not properly served, nor was the town. If you'll just allow me to argue my motion to set aside the default judgment against the town, Your Honor, you'll hear that.
Mr. Terry, the motion to set aside the default against the town, is that only related to count 3? Can you explain for the court as to what that involved, or is it too inextricably entwined with Mr. Bassett that we can proceed? If you could please clarify for the court in your complaint.
I'm sorry, Your Honor, I didn't catch that question in full. Could you say it again?
Okay, my question to you, Mr. Terry, is Mr. Rael is asking to proceed on the motion to set aside the default judgment as relates to the town of Edgewood, and the court is of the understanding this only relates to count 3 on the writ of mandamus. It appears that Mr. Riles argued that this is broader and that they're inextricably entwined, which I've already stated is of concern to the court, because if he cannot move forward and represent only the town, then we should not proceed. And if you could explain for the court, if as your complaint is alleged, is it so inextricably intertwined that Mr. Riles cannot address defending the town without Mr. Terry, as how you've alleged it in the complaint?
I would start with this, Your Honor. I am not 100% sure that I understand Mr. Riles' argument in its entirety, but I don't know that that's necessarily important. I think what's true is that based on your prior ruling moments ago about allowing intervention based on the movement's motion filed yesterday, and that order is to require the town to take action or not on the issue of how they would like to proceed on the count, I don't think that we can argue the motion to lift the default, because it may be the case that the town actually wants that writ of mandamus to go into effect or to take practical action to make it effective.
Thank you, Mr. Terry. All right, I'm going to deny Mr. Riles that we proceed at this time on any motions. They are inextricably intertwined, and I think we need to allow the town of Edgewood to make their decision as how they want to proceed. So with that being said, the court has made their ruling, and I've asked Ms. Jaramillo to get that order back to the parties and then return that to the court by end of the week. Anything else the court can address to the parties at this time?
Nothing from the plaintiff, Your Honor.
All right.
No, Your Honor, thank you.
Yes, Mr. Riles.
Your Honor, so until these motions are filed and you set another hearing, you're telling me that you're going to allow a writ of mandamus saying that Mayor Bassett is no longer mayor, or you're waiting until you've had a chance to hear those motions after they've been filed?
Okay. The court is granting motion to strike any of the pleadings that have been filed. So as it stands, the default order is in place, and that is the order in place. Any of the motions are not pending, are considered stricken because the court's found that you did not have the standing, Mr. Riles. So for that purpose, the order for default remains in place as the last order in this matter.
I don't understand how the town is supposed to operate, Your Honor.
I would suggest that the counselors of the governing body will make that determination, Mr. Riles. Thank you very much. There be nothing further. This matter is adjourned. You may hang up.
Thank you, Your Honor.
Thank you.